Welcome to the deep dive. We've got a really interesting set of legal analyses you sent over, focusing on, well, how courts are trying to speed things up in a pretty tricky area.
That's right. We're talking about the clash between creditors chasing debts and debtors sometimes desperately trying to avoid payment.
Exactly. And our mission today is to dig into a specific strategic legal maneuver that seems to be shaking up how these insolvency fights get resolved. We're looking at how courts are trying to cut through delays and, well, the sources call them flimsy defenses.
Flimsy is the word they use.
Okay, so let's unpack that. We're diving into that complex point where two big legal ideas meet. Winding up applications, the move to declare a company insolvent in summary judgment.
That quick judicial decision you can get if a defense looks totally baseless.
Right?
Without needing a full trial.
Precisely. And how these two previously often separate processes are now being linked in a really innovative way.
Yeah, and that linkage is key. Historically, winding up could get bogged down so easily. A debtor facing the inevitable could just, raise some minor issue, maybe dispute a tiny part of the debt.
And force the creditor into this long, expensive side battle, a full trial, even if the defense was weak.
Exactly. Months, even years, could pass before the main insolvency issue was even addressed. It was ripe for tactical delays.
So the focus now, based on these materials, is really on efficiency, getting things moving.
It's all about optimizing the system. The sources highlight this synergy, this link between summary judgment and winding up, being used to push creditor rights forward much faster. The core question really becomes, how well can the court now spot and deal with defenses that are just stalling tactics?
Okay, let's get specific.
Right.
The case everyone points to is Rohling-Grindrod, Plebity, LTD v. Selemo Valley Farms, Plebity, the LTD. This is where the innovation really shines, right?
It is.
The creditor didn't just file for winding up and wait. They actually integrated a summary judgment application into the winding up process itself.
Which sounds technical, but the shift in strategy is huge. Think of winding up like, a marathon.
Okay.
Previously, the debtor could throw up a hurdle saying, wait, we dispute this tiny detail. And that forced the creditor, the runner, to go run a whole separate race, a full trial, just to clear that hurdle before coming back to the marathon.
Totally derailing the main event.
Exactly. But what the court allowed in Rohling-Grindrod was like merging the races. It let the summary judgment step in immediately. The court basically says, okay, pause the marathon. We're doing a quick sprint right now to test this defense you've raised.
A pressure test.
A real pressure test.
Yeah.
Does this defense have any real substance? If not, it's dismissed, hurdle cleared, and we get right back to the main race, the insolvency decision.
That makes sense. That idea of immediate pressure test really highlights what they mean by judicial efficiency. It's not just about saving court admin time, is it?
Not at all. It's about stopping the process itself from being used as a weapon. Preventing debtors from just gaming the system to delay paying what they owe.
So the Rohling-Grindrod precedent, it's powerful because it changes the game for debtors thinking about stalling.
Fundamentally, when the court okayed linking these procedures, it sent a massive signal. Two key outcomes, really.
Which are?
First, it obviously saves court resources.
Yeah.
No need for drawn-out discovery and trials for defenses that are, frankly, often just made up. The court showed it could spot a stall tactic early.
Okay. Makes sense.
And second, maybe more importantly for the interest of justice, it stopped debtors from tying up assets and frustrating legitimate creditors just by dragging things out endlessly.
But hang on a second. If we're prioritizing speed like this, isn't there a danger? Could a court, in trying to be efficient, accidentally throw out a defense that's actually genuine but just really complicated, one that needs time and evidence?
That's the crucial question, absolutely. Where's the line?
Yeah, how high is the bar now for a defense to be called insubstantial?
Well, the precedent suggests the bar for summary dismissal, throwing it out quickly, is still appropriately high. What seems to have shifted is the definition of a genuine dispute in this specific context.
Okay.
The court isn't meant to be dismissing genuinely complex arguments. It's targeting defenses that look, well, obviously evasive or dishonest on their face, things specifically designed just to delay the winding up.
So if the defense is based on, say, a really tortured reading of a contract, not a real factual disagreement.
Exactly. In summary judgment, the court looks at the papers. Is there a triable issue of fact? If the debtor's argument is just a bizarre legal interpretation or contradicts the clear contract terms, the court can say, look, there's no real fact we need a trial to decide here. This is just a baseless legal argument, and bypass the trial for that issue.
Okay, that really sets the stage for digging into what the debtor actually argued in Rohling-Grindrod. If this is the benchmark for a flimsy defense, we need to understand it. So the source material says they didn't really deny the debt existed initially. Instead, they pointed to one specific clause in the contract.
That's right.
And argued this clause somehow meant they weren't liable, or at least not yet, under the circumstances. It sounds like a very technical, find a loophole kind of defense.
It was. And the court's analysis is probably the most revealing part. They didn't just say that the defense was weak, they called it insubstantial and, crucially, evasive.
Evasive. That's strong.
Very strong. To give you a flavor, the debtor tried to argue that a particular payment term wasn't just a deadline, but acted like some kind of security or indemnity.
Implying the debt wasn't technically due and payable yet for the winding up application.
Precisely. They tried to twist the meaning. The court didn't just disagree. It found the interpretation to be, self-serving and completely against what the contract clearly intended.
So the court looked past the technical jargon and basically said, come on, this isn't a real legal debate. This is just you trying to wiggle out of paying and stall the inevitable.
That's the essence of it. And that finding that the defense seemed patently dishonest was the key. That's what allowed the summary judgment part of the application to succeed and clear the path for the winding up.
Wow.
It sends a huge message. Courts are losing patience with these kinds of tactics. If your defense smells like a pure delay tactic, there's now a faster way to shut it down.
Right. Which brings us neatly to the practical side of things. What does this mean for creditors now? If you're owed money and the debtor's raising questionable objections, what's the new playbook?
It's a definite strategic shift. Creditors can now be more aggressive, more confident perhaps. By filing for summary judgment alongside the winding up application, they're signaling to the court right away, we believe there's no real defense here.
And that potentially speeds everything up dramatically?
Potentially, yes. It enhances the chances of recovery by cutting short that old cycle of delays. It forces the issue much earlier.
But is it risky for the creditor, too?
Good point. Yes, it is. This is an assertive move. If a creditor tries this combined approach, files for summary judgment, and then it turns out the debtor does manage to convince the court there's a genuine tribal issue.
Then the creditor's strategy backfired.
Exactly. They've wasted time and money on the summary judgment part. So it encourages creditors to be absolutely certain their debt is clear-cut, and the anticipated defense really is nonsense before they pull this trigger. It demands better preparation up front.
So it's not a magic wand, but a powerful tool for creditors who are very confident in their position. It sharpens things on both sides, really.
That's a perfect way to put it. Debtors can't rely on purely procedural stalling as easily. Creditors need their ducks in a row before making this aggressive move.
And the court gets to focus quicker on the main questions. Is the money owed? Is the company actually insolvent?
Precisely. That's the ultimate effect highlighted in the sources. Creditors can pursue winding up more confidently, knowing the court has this mechanism to handle overlapping issues efficiently and prevent endless stalling. It takes away the debtor's ability to just weaponize time.
Okay, so let's wrap up this deep dive. The big takeaway from the material seems clear. This integration of summary judgment into winding up, especially following Rohling-Grindrod, is seen as a significant step forward.
A major regulatory advancement, as one source put it. It's about making sure the legal process itself doesn't punish the party who is actually owed money.
Yeah, it feels like the judiciary adapting, becoming more pragmatic about commercial realities.
It definitely enhances how insolvency law works in practice. And it acts as a safeguard against debtors just trying to play the system, assuming, of course, the debt itself is solid. It aims for a fairer, faster process.
Right. The courts have clearly signaled they want efficiency and are willing to dismiss defenses that look flimsy to get there. And for creditors with clear claims, that's obviously good news. But it does leave you with a final thought, doesn't it?
Oh.
Well, thinking ahead, if the system increasingly values speed, using these kinds of high-pressure checks like summary judgment, what happens when a debtor does have a genuine defense, but it's incredibly complex, maybe something needing months of forensic accounting or expert analysis just to explain properly?
Yeah, the potential collision between efficiency and genuine complexity.
Exactly. Where does that leave a debtor with a real but difficult case when the system is geared towards faster, simpler resolutions? How does the need for speed square with the need for thoroughness in those really tricky situations?
There's definitely something to keep an eye on as this approach becomes more common.
Something for you to mull over. And that's all we have time for on this deep dive. Thanks for joining us as we looked at how legal innovation is changing the debt recovery landscape.